Breach of contract and its remedies. We have so far seen how a contract is made, the essential of a valid contract, and also how a contract is to be performed, as well as how a contract may be put an end. We shall now discuss about the breach of contract and also the mode in which compensation for breach of contract is estimated. Breach means failure of a party to perform his or her obligation under a contract. Breach of contract may arise in two ways. The actual breach of contract and anticipatory breach of contract. Breach of contract. Anticipatory breach of contract. An anticipatory breach of contract is a breach of contract occurring before the time fixed for performance has arrived. When the promiser refuses altogether to perform his promise and signifies his unwillingness even before the time for performance has arrived, it is called anticipatory breach. Effect of anticipatory breach. The promisee is excused from performance or from further performance. Further, he gets an option to either treat the contract as rescinded and sue the other party for damages, or he may elect not to rescind but to treat the contract as still operative and wait for the time of performance. Actual breach of contract. In contrast to anticipatory breach, it is a case of refusal to perform the promise on the scheduled date. The parties to a lawful contract are bound to perform their respective promises. But when one of the parties breaks the contract by refusing to perform his promise, he is said to have committed a breach. Actual breach of contract may be committed. Actual breach of contract may be committed at the time when the performance of the contract is due, or during the performance of the contract, that is, one party fails or refuses to perform his obligation under it by express or implied act. Suit for damages. Compensation for loss or damage caused by breach of contract. When a contract has been broken, the party who suffers by such a breach is entitled to receive, from the party who has broken the contract, compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things from such breach. Compensation for failure to discharge obligation resembling those created by contract. When an obligation resembling those created by contract has been incurred and has not been discharged, any person injured by the failure to discharge it is entitled to receive the same compensation from the party in default, as if such person had contracted to discharge it and had broken his contract. Remedy by way of damages or kind of damages. Remedy by way of damages is the most common remedy available to the injured party. This entitles the injured party to recover compensation for the loss suffered by it due to the breach of contract, from the party who causes the breach. Types of damages. Ordinary damages. When a contract has been broken, the party who suffers by such breach is entitled to receive, from the party who has broken the contract, compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things from such breach. Special damages. Where a party to a contract receives a notice of special circumstances affecting the contract, he will be liable not only for damages arising naturally and directly from the breach but also for special damages. Vindictive or exemplary damages. These damages may be awarded only in two cases. They are for breach of promise to marry because it causes injury to his or her feelings, and for wrongful dishonor by a banker of his customer's check because in this case the injury that it causes loss of credit and reputation to him. Types of damages. Nominal damages. Nominal damages are awarded where the plaintiff has proved that there has been a breach of contract, but he has not in fact suffered any real damage. It is awarded just to establish the right to decree for the breach of contract. Damages for deterioration caused by delay. In the case of deterioration caused to goods by delay, damages can be recovered from carrier even without notice. The word deterioration not only implies physical damages to the goods, but it may also mean loss of special opportunity for sale. Prefixed damages. Sometimes, parties to a contract stipulate at the time of its formation that on a breach of contract by any of them, a certain amount will be payable as damage. It may amount to either liquidated damages or a penalty. Penalty and liquidated damages. English law. According to English law, the sum so fixed in the contract may be interpreted either as liquidated damages or as a penalty. But where the sum fixed in the contract is unreasonable and is used to force the other party to perform the contract, it is penalty. Indian law. Indian law makes no distinction between penalty and liquidated damages. The courts in India award only a reasonable compensation not exceeding the sum so mentioned in the contract. A decree is to be passed only for reasonable compensation not exceeding the sum named by the parties. Party rightfully rescinding contract, entitled to compensation. A person who rightfully rescinds a contract is entitled to compensation for any damage which he has sustained through non-fulfillment of the contract. Claiming damages as a remedy for the breach of contract. Rescission of contract. When a contract is broken by one party, the other party may treat the contract as rescinded. In such a case he is absolved of all his obligations under the contract and is entitled to compensation for any damages that he might have suffered. Suit for specific performance. Where one person has rendered service to another in circumstances which indicate an understanding between them that it is to be paid for although no particular remuneration has been fixed, the law will infer a promise to pay. Quantum meruit. Where damages are not an adequate remedy in the case of breach of contract, the court may in its discretion on a suit for specific performance direct party in breach, to carry out his promise according to the terms of the contract. Suit for injunction. Where a party to a contract is negating the terms of a contract, the court may by issuing an injunction orders, restrain him from doing what he promised not to do.